drafting a response to the Attorney General of the state of Minnesota, who is defending partisan abuse of government records in order to help the campaign of Betty McCollum for the U.S. House of Representatives, as well as that of Mark Ritchie, who has just announced that he will not run again for his office as the Chief Elections Officer of Minnesota. And here's that draft. Incredibly enough, the Attorney General office led off their motion to dismiss by arguing plaintiff's lawsuit is based on non-existent constitutional rights. This court's opinion does not say my constitutional rights are non-existent. Notably, defendant's response contains no mention of the First Amendment and why the Secretary is entitled under that amendment and the Equal Protection Clause to give himself the First Amendment right to raise money for his own campaign and that of other Democrats, while at the same time arbitrarily denying those same rights secured by the U.S. Constitution to me as a nominee of the Minnesota Independence Party. A careful constitutional analysis is called for in this motion, and in the case as a whole, to ensure that email addresses collected by the government are not used by partisan officials to create an advantage for one candidate or another, or to restrict freedom of speech or association. Secondly, Secretary Ritchie ignores the Minnesota Government Data Practices Act. But without this act, Secretary Ritchie simply has no authority whatsoever to collect the 12,000 email addresses he did for the purpose of campaigning and fundraising for himself, or for collecting any government data on voter application forms. And yet now defendants claim explicit discretion to manipulate all of the email addresses collected from Minnesota voters. In this instance, that explicit discretion has included giving himself 12,000 email addresses to raise funds and support for his own campaign for Chief Elections Officer, no less. It then allowed him to lie to this court, claiming that the law precludes him from giving government data in the form of email addresses to me. Finally, it allowed him to disregard IPAD's decisions and claim explicit discretion to determine which candidates and parties will have access to government-controlled email addresses. At this point, to the extent that the U.S. Constitution ever gave Secretary Ritchie such discretion, he has clearly abused it. He has exceeded his authority and acted ultra vires. While the creativity shown by defendants to benefit themselves through their offices is impressive, it cannot be allowed in a federal election because it does not meet the standards of the U.S. Constitution, which authorizes the state to send representatives to the U.S. House of Representatives, in this case, in the first place. They can't help their party's candidate by denying public information to the opposing candidates. The 12,000 email addresses Secretary Ritchie took from his office to use for campaign purposes, including fundraising, were government data as much as the email addresses from the 4th Congressional District registering voters. As such, these addresses in question in the 4th CD were governed by the Minnesota Government Data Practices Act just as much as the 12,000 he took home with him were. Both government data, both covered by the MGDPA. And yet, the only time defendants have ever mentioned any portion of the MGDPA, it was to say that they should have charged me thousands of dollars to give me the addresses. This is particularly troubling since it appears defendant Ritchie is classified by law as the responsible authority and as the designee to implement the law. As such, he was only authorized by MGDPA to even collect the emails. He could not have lawfully collected the information without such authorization. This case is about the treatment of my rights on October 29, 2012, to the email addresses I was offered and paid for in the heat of the 2012 election, in which this electronic medium of contacting the voters was intended to play a key role. This area is heavily regulated by the First Amendment, and there is a long history of critical judicial precedents protecting my rights under the First Amendment as a voter and as the nominee for federal office, especially since Buckley versus Vallejo, 424 U.S. 1, 1976. But the state, in turn, has asserted that its chief elections officer has explicit discretion over the use or release or availability of voter contact information during the election he is administering. The state's conduct of federal elections is regulated by Congress and the Constitution. The Constitution regulates restrictions of free speech and association during the election by the state, and plaintiff's position, while apparently heretofore rejected by this court, is that interpreting MGDPA's regulation of email addresses to allow only some candidates, in this case Secretary Ritchie, email addresses held as government data violates equal protection, while restricting the use of email addresses by any parties or candidates would violate the First Amendment rights of free association and political speech, especially during the heat of a campaign. This court must construe the actions of the chief elections officer and the laws and policies of the state in view of these heavily protected political speech and association rights, and so far this court has not. There has been no opportunity for discovery at all, for gathering evidence at all, because the case was quickly dismissed before the scheduled pretrial conference. Exhibit B shows the DFL strategy of restricting and manipulating free speech by government-controlled email addresses when Betty McCollum began to attack the use of the email addresses data in her primary with Lohengrin, and at the same time called for the cutoff of email addresses by the state. Ritchie, through Bert Black, then intervened to disallow the staff person who offered and provided me the form to obtain the disk with the emails on it from giving me any email addresses. Facts. The response concedes that Ritchie in 2007 held roundtable discussions with various individuals and organizations at which those entities discussed their current activities and plans pertaining to expanding civic education in Minnesota, unquote. The Office of Legislative Auditor, OLA, Financial Audit Division, has in its mission to promote accountability, strengthen legislative oversight, and support good financial management. The Attorney General Office then concedes, point blank, that, quote, the Secretary subsequently provided his campaign with email addresses from this compilation of civic education contact information. That's citing the legislative audit. Further, they admit, quote, on October 29th, 2007, two individuals who had received fundraising email messages from the Secretary's campaign as a result of the above facts filed a complaint with the Minnesota Office of Legislative Auditor. On October 29th, 2012, defendants informed plaintiff they would not allow me to have any of the email addresses. There is no denial from defendants that those 12,000 civic education email addresses overlapped with names of CD4 registering voters who also gave their email addresses to Mr. Ritchie and his office via voter registration forms. But the Attorney General representing the defendants claims there is a great distinction between the very same names on their civic education list and on the voter registration list. That distinction is untenable, dubious, and legally baseless. They have failed to persuasively establish any distinction, and this court should find that there is no distinction. Both lists are government data, and the MGDPA should be used to analyze these attempted distinctions, and then the Constitution of the United States of America should be used to analyze the application of the MGDPA to see if such actions and policies by state officials meet constitutional muster. Plaintiff strongly urges they do not meet constitutional muster.